I don't think I've ever had a musical introduction like that. It's a little daunting. It's a little daunting. But let me begin by saying just how absolutely delighted I am to be here, my first time in Helsinki, on what has been a beautiful, bright, sparkly, sunny visit so far. And I also want to begin with appreciation and congratulations to the organizers, to Heidi and Petra and Rika and all people who have been involved with the Arbitration Institute for the Finland Chamber of for the Finland Chamber of Commerce. They've brought together a truly illustrious group. And we heard already how thoughtful the energy is that they put in to determine the topics that we're going to discuss today. Now, at first blush, the title of the conference, Shaping the Future of International Arbitration, sounds like you might have just found it on Google, because so many conferences today use the word future, okay, in their titles, because it sounds good to be forward-looking, okay? But I want to compliment the organizers and those who chose that language, not on the word future, but on the word shaping, because I think this is actually something that makes the choice of topics for today unique. Maybe it's just because I am a scholar who focuses on professional conduct and ethics, that to me the word shaping means something different than let's see what happens in the future, or let's talk about what we think might happen in the future. This simple reference to the word shaping, I believe, implies both a custodianship, someone has to do this shaping, and an exhortation to be responsible in exercising that custodianship. Shape implies an intentional act towards a particular design. So the phrase shaping the future of international arbitration, I think, is a tall order and a great way to organize or to inspire the topics for today. So with my remarks today, I'm not going to concentrate on the specific aspects of technology and transparency, and I can't profess to know much about sports arbitration, but I am going to talk about what I think will be involved for the international arbitration community to shape and in fact respond to some of the changes that will be coming as a result of these developments. So as a starting point, when we think about shaping something, we have to start with what is the form that's before us. We are not starting in international arbitration with a blob of clay that we're going to shape something new out of. Instead, I think we are starting with something that is a truly exceptional mechanism, in many ways nothing short of miraculous, this process of international arbitration that we have. It is highly unique and counterintuitive in many ways as a process that can transcend national boundaries and most often international politics. To illustrate its uniqueness, I would like to invoke a metaphor, that of the bumblebee. So more specifically, actually, the flight of the bumblebee. So for most of our history, it was actually believed that bumblebees should not be able to fly. It confounded everyone. How could they fly? The physicists said, their body mass is too heavy, and their wings are just simply too small. The aeronautics engineers observed that their wings flapped too slowly, and even more shockingly and counterintuitively, they don't flap in a synchronized fashion. They actually flap independently. By all accounts, these defects in the bumblebee should have made it completely impossible to fly, according to all theories that were known. As a matter of fact, we developed supersonic jets and put astronauts on the moon before we figured out the mechanics of how a bumblebee can fly. I would suggest that international arbitration is in many ways like the bumblebee, in that if we describe this process to someone who didn't know anything about it, it would be very counterintuitive that it works. But they did figure out eventually how the bumblebee could fly, and we will discuss later also how it is that international arbitration works so well and what that might portend for shaping its future. So as it turns out, in the 1990s, really a short time ago, if you think about the history of the bumblebee, the insect's physics-defying acrobatics were finally determined to be part of a process by which their wings develop a swirling tight circle a vortex of air and off the edge of their wings, which actually ends up giving them some lift. It sucks them upwards in a way that helps them buzz around in a manner that otherwise shouldn't seem to be possible. A related theory that was actually just developed as recently as 2009 posits that instead of conventional aerodynamics and this vortex alone, in fact, the bumblebee flies through brute force. It has, through evolution, developed this enormous thorax that it's so distinguished for, and that makes it seem counterintuitive that it can fly because that's so heavy. But that is also essentially what gives it its muscle to just brutally force itself to defy gravity. In international arbitration, I think we also defy gravity and the physics and dynamics of how adjudication is presumed to operate and exist. In traditional adjudication, sovereign governments build physical courthouses. They appoint judges who are then clothed in formal robes, given a judicial bench and oftentimes a gavel, and court officers so that they can effectively apply their power to enforce government's laws to the disputes among citizens. Now, international arbitration has none of these physical characteristics, none of these essential features. Yet it somehow, and particularly with regard to many international disputes, functions better than national courts could in its stead. So international arbitration, in contrast to these features of domestic adjudication, does not have essentially any physical existence. It's a highly decentralized regime. Yes, we have arbitral institutions, and they are housed in buildings, and those buildings sometimes host arbitral hearings. But just as the bumblebee's wings flap independently, the physicality of an arbitral institution can be completely independent of the legal seat, which in turn can be independent of where the hearings actually occur, which in turn can be independent of the law to be applied, and in turn can be independent of where the awards are enforced. This physical disjuncture is in fact what makes international arbitration work. But if you tried to describe that to someone who had never experienced or been involved in the system, it would seem quite counterintuitive. Instead, I believe it is these unique features working together, swirling together, that create the vortex that gives international arbitration its lift to transcend international legal cultures and legal regimes. Meanwhile, international arbitration, as we all know, does not have an established cadre of judges who wear robes and act with sovereign authority. They instead, like the bumblebee, use what I would characterize as brute force of their experience and their expertise to obtain ad hoc appointments, to resolve their disputes in creative and often innovative ways, and to have those decisions respected. Now, despite the lacking of conventional features, international arbitration today, as a result of its uniqueness, is being asked to resolve more and more disputes. By some estimates, we might say that there are over 10,000 disputes, depending which institutions or categories of arbitration, international arbitration you include, but 10,000 disputes annually worldwide. These arbitrations move around the globe, quite literally trillions of dollars. They implicate national policies, including some that are considered essential to national public interests. And they resolve a remarkably nuanced number of disputes that involve different legal cultures, legal traditions, and conflict of law issues. The remarkable legacy this remarkable legacy is where we start when we talk about shaping the future of international arbitration. This is what the shapers of the future of international arbitration must preserve and contend with. However, they are also facing a number of important new challenges to be able to help international arbitration along this way. Challenges from what we see as rising nationalism, assertions of preference for politics over rule of law, and perhaps most distressingly, a question of whether there is even such a thing as a fact, or whether everyone is simply entitled to their own alternative facts. Progress in international arbitration, I think, has to not only address these issues effectively, but also transcend them. And it will do so in many ways similar to that of the Bumblebee, but we do need people to come in and shape the future. So the Bumblebee developed its various features through Darwinian evolution, and international arbitration has, in many respects, developed its most salient features through evolution, the evolution that occurs when individuals bring specific cases on behalf of their clients and seek to enforce the awards that result. But there are two areas I'm going to focus on as an illustration where I think international arbitration, the shapers of the future of international arbitration, need to intervene, and in fact, in some instances, have already started intervening to make sure that the evolutionary trends result in a more salient result overall for international arbitration. And I'm going to speak briefly about the role of international arbitrators and transparency in a slightly more abstract way than we'll be learning about or talking about on the panels. So to look at these two trends, and again to invoke a little bit our historical and evolutionary metaphor, if we go back to international arbitration's Big Bang moment, which I would consider the drafting and ratification of the New York Convention in 1958, most arbitrations at that point involved relatively simple private contract disputes. In that era, the non-arbitrability doctrine was alive and well, meaning that most types of disputes that involved statutory claims, securities fraud, antitrust, could not be arbitrated. You couldn't arbitrate also claims involving corruption or allegations of corruption. If a case involved any of these claims, you had to cease the arbitration, go to national court to get these non-arbitrable issues resolved, and then go back to international arbitration. Arbitrators lacked the authority over provisional measures, any ability to consider consolidating separate proceedings, to rule that amicus, non-parties to the arbitration, could make submissions, and they had severe limitations on a number of their ability to exercise a number of other procedural powers that are today taken for granted. In the last 30 years, most specifically, we have seen the power of international arbitration and specifically of international arbitrators expand dramatically, I would say mainly as a result of evolutionary pressures. So let's take a few examples. Interim relief. Parties historically had no choice if they needed interim relief but to go to national courts because interim relief granted by arbitrators was unenforceable, and as a result, they were effectively reluctant to even issue it. Today, interim relief is more supported by national courts, and even more interestingly, we now have something called emergency arbitrators, who are generally recognized as being more effective and more efficient at granting relief than national courts could ever be. Arbitral jurisdiction has also expanded in very important ways. Most importantly, in addition to the demise of the non-arbitrability doctrine generally, we are seeing new doctrines emerge, like doctrines that allow non-signatories to arbitration agreements to nevertheless be subject to the power of arbitrators. We are seeing arbitrators determine within their own initial power issues of joinder, intervention, consolidation. We're seeing in individual cases procedural rulings and formal rulings that are more creative than what national courts are able to do because they exist within confined rules and national legal cultures that don't allow the kinds of creativity that are being imagined in international arbitration and resolved there on a daily basis. Perhaps most importantly, we're also seeing international arbitrators and international arbitration adjust to powers of arbitrators to react to certain new trends, including, for example, what should they do when there is a third-party funder who becomes involved, and what can they do if counsel is misbehaving severely. Finally, I'm going to touch on what I think is yet another really important challenge as we think about shaping the future of international arbitration, and that's bribery and corruption. Again, it used to be beyond the power even imagined for arbitrators to take up these issues. You had to dismiss a case immediately or stay the proceedings to allow a court to resolve those issues. Today, it's recognized in most jurisdictions around the world that arbitrators do have the power to resolve disputes involving bribery and corruption. Most importantly, however, particularly in investment arbitration, we are seeing international arbitration grapple and arbitrators wrestle very specifically with how directly they should be involved when allegations of corruption and misconduct have been alleged, and what their obligations are, not solely to the parties before them, but to the policy interests and the individuals who might otherwise be affected. Arbitrators are today increasingly being pressed to deal with corollary criminal proceedings or investigations, either by ordering suspension of criminal prosecutions by state parties in some instances, in order to protect the arbitral proceedings, by investigating allegations of criminal misconduct, by taking or refusing to take evidence in accordance to demonstrate the existence of criminal conduct or corruption, or by referring potential criminal conduct for police action. Finally, and this is a point we started at earlier, as a result of all this expansion procedurally and in the power of international arbitration, we are also seeing, as a result of the expansion in overall numbers, some challenges to what the primary constituencies are of international arbitration. Historically had been a primarily, if not exclusively, European affair. North Americans only came in the 1970s, still before they figured out how bumblebees could fly. But today we see the dominance still of international law firms, but also steep increasing caseload growth, primarily in the 2000s in Asia, more recently in Latin America, Africa, and Middle East. Now, all these changes that I've just described, I think, occurred as an evolutionary matter. They occurred naturally as a result of parties arguing their cases and arbitrators responding to what was put before them. But these evolutionary advances also raise some challenges and some requirements that an active role be taken in shaping the future of international arbitration. Now, some of those activist interventions, I think, have already occurred. So, for example, one of the risks that I think has come up during some of these earlier trends that we were talking about is that arbitrators might have an interest or act in their own self-interest, most particularly by not disclosing conflicts of interest or taking too narrow a view of what constitutes a conflict of interest to ensure that they can get more appointments. If you disclose the conflict, you're less likely to get appointed. We've seen some really important innovations in that area, most particularly by the International Bar Association's Guidelines on Conflicts of Interest, first enacted in 2004 and then revised in 2014, which broadened the scope of materials that need to be disclosed and therefore reduced the discretion of arbitrators in deciding whether to disclose it. Another more recent problem, which we may hear about when we hear from the in-house counsel's perspective, is there is a concern that arbitrators might be taking on, some of the leading arbitrators, too many cases, with the result being that it's taking them too long to be able to schedule hearings and write the awards in those cases. In other words, they're sort of as victims of their own success, and as a result, performing less well by delaying the process overall. Here again, we've seen, I think, some direct intervention to shape the future on this issue, particularly by arbitral institutions, which are increasingly asking arbitrators to disclose the number of cases in which they're available, and by general discussions led in many instances by arbitral institutions to highlight the obligation of arbitrators to not only resolve disputes, but to ensure when they take on a new dispute that they have the time to resolve it efficiently and competently. And then, of course, also this tremendous expansion has raised questions about diversity among arbitrators. Again, it started primarily as a European affair with North America coming in, and as a result, perhaps of natural evolutionary pressures, it means that the first arrivers, predominantly older men, but also predominantly North Americans and Europeans, had a sort of lock on the market for international arbitrator services. And that particularly has been an area where we've seen more recently a lot of efforts to shape the future, a lot of direct intervention to take over where evolution has left off. We see a number of important innovations, from the pledge to the alliance, to arbitral institutions publishing names of individuals, publishing statistics about how diverse the arbitrators are who they're appointing. These are the kinds of interventions to, in a sense, redirect evolutionary trends that are important. I would like to suggest that there's one other area where direct nudges from arbitral institutions, but also from entities or from events like this. Opportunities where we take a step back and say not just what's happening, what do we see happening, where do we think it might go, but we take an opportunity to say what should we do as custodians who have an interest in the continued success of international arbitration, what should we do to help shape its future? And it's for that reason that I really believe that opportunities like this, where we bring together a range of people who are interested in the subject, who are committed to it, a number of people, and I think it's fair to say everyone in the room, maybe with the exception of that small group of students are in that group, are in the group of custodians. We said non-lawyers, maybe they're just here because they have a friend or something. But really everyone in this room, I think, is in charge of taking into account some of the insights from today to help shape the future. And that brings me back in closing to why I think it's so great that this event is in Helsinki, apart from the fact that it's so lovely to be here. And that is because Finland has actually been a major leader in transparency. In preparing for this, I found out that Finland has one of the oldest Freedom of Information Acts in the entire world. It was enacted in 1766. Just, that's, hundreds of years before we figured out how the Bumblebee can fly. And Finland also ranks in the world's leading, most innovative countries. And in learning about how Finland is able to accomplish that, because I don't know that it's so counterintuitive that this Scandinavian country that's actually quite small, nevertheless ends up being a world leader in it. And it's in part, without going into details about things my hosts know much better than I do, Finland has taken a number of specific steps to try and guide future innovation, to shape the future of innovation in Finland, which then in turn shapes those innovations in the world. So with that, I know we have a fantastic program ahead of us that's going to take some of these more general insights and apply them to specific areas. I do, before I close, I have to say I did one other, that I forgot, one other innovation that I think is particularly interesting and important, I don't know if it'll be talked about in the sports arbitration section, is the elimination of double hatting by the Court of Arbitration for Sport, which is a really interesting and deliberative, I would say, reshaping of the natural trajectory to increase the legitimacy and effectiveness of that institution. So with all of these items on the table and in the beautiful room that we're in this beautiful city, I'm so pleased to say let the day begin.